thank you to the organizers for putting together this conversation, and I look forward to the interchange that we're going to be having. I'm going to approach this question from a somewhat different perspective than Helen has just offered. I'm not a Roman Catholic. I do not share the Church's theology with respect to contraception. I'm here because of my interest and commitment to religious liberty, and so to my mind, the issue here is not related to the specifics of the mandate, but rather to the unprecedented decision to require not only religious institutions but also other Americans to pay for something that they regard as deeply contrary to their beliefs. And I want to organize my remarks around legal categories. I'm a law professor, not a theologian, and so that's the way I tend to think. There are two bodies of law which are applicable to this question. One is statutory and the other is constitutional. Statutory, the main constraint here is the Religious Freedom Restoration Act, which was passed in 1993, signed by President Clinton. Marty Lederman used to be the fellow in the Clinton administration who was responsible, among other things, for early interpretations and for making sure that it was given its full effect. And that law provides that whenever actions of the federal government impose a substantial burden on the exercise of religion, that they can be sustained only if they are the least restrictive means of achieving a compelling governmental interest. And that's actually how I'm going to organize remarks. As first, is this a substantial burden on the exercise of religion? And second, is it a narrowly tailored means of serving an important governmental purpose? In addition to that, there is the free exercise and establishment clauses of the First Amendment, which are guarantees of religious freedom. Just a few months ago, the United States Supreme Court rendered a remarkably powerful, unanimous decision reemphasizing the protection that religious institutions have for being able to make decisions important to their beliefs and their mission. A unanimous decision, I might add, rejecting the argument of the Justice Department and this administration that the Free Exercise and Establishment Clause provided no special protection to religious institutions at all. Interestingly, even Justice Kagan, who had been the Solicitor General not that long ago, joined in an opinion emphatically rejecting that argument, calling it remarkable, which is kind of judge speak for really out of line. I wonder if this contraceptive mandate is not a product of the same kind of legal thinking that went into that brief. So let me begin first with the burden. I don't think that there can be much doubt that requiring a religious institution to pay for services that it regards as immoral or evil is a burden on the exercise of religion. That seems to me to be rather obvious. Let me give an analogy, though, just if this might be helpful. I have no doubt that the federal government can, as a policy, make contraceptive services and sterilization and abortifacients available as a matter of federal policy. The analogy here is to making war. I have no doubt that the federal government has a right to have a military establishment and to make war. It can use tax money that comes into the general treasury to do that, even though many Americans have a religious and sometimes non-religious moral objection to warfare. Right? But that doesn't mean that the federal government is unable to pursue its objectives. But what the federal government cannot do is require religious institutions or conscientiously objecting individual citizens to make war for them, right? So that they cannot conscript the churches of America into assisting in the war effort. And throughout American history, we have always provided exemptions for religious conscientious objectors so that individuals do not have to make war contrary to religious conscience. It's not that warfare is not important, right? It's that conscience is important as well. And I think similarly here, it isn't that there's any restriction on the federal government in pursuing its particular understanding of healthcare services in America. It's that they cannot conscript religious institutions and individuals into carrying out that program for them. And I think that the administration's policy actually acknowledges that that is so, because from the beginning, and even before all of the commotion, the administration exempted some religious institutions precisely on the ground that they did understand that this would be a burden on their religious conscience. However, it only exempted those religious institutions that primarily serve members of the religion itself. And in an initial version of this, they called this houses of worship. And that's essentially what it is the houses of worship exception. As if churches in America did not do things like run soup kitchens, have adoption services, have international aid relief, aid for the poor, hospitals, schools, and so forth, as if churches were only places where people retreat on Sunday mornings in order to talk among themselves. And so I think the administration seems to recognize the burden on the exercise of religion, but wanted to confine this to just to houses of worship. And I think this seems to reflect a view, and if you listen to the rhetoric that comes from the administration on the subject, they actually very rarely refer to the exercise of religion. They speak instead of the freedom to worship, as if that is what religion is about, is worship rather than serving God in all the manifest ways in which religious institutions do so. Well, after the commotion, and under a great deal of political heat, the president announced that there would be a so-called compromise. Now, first of all, we have not yet seen the compromise. The present rule is a final rule. It is in effect. There is a proposed rulemaking which does nothing other than ask people to make comments on how can we possibly provide free services of this sort to employees of religious institutions without anybody having to pay for it. My guess is that Econ 101 will kick in at some point and they will realize, no, that is not a possible proposition. But in the meantime, we have regulations that are final and in place requiring religious institutions to buckle under. But let's think about the compromise for just a moment. As I understand it, the idea is this, that the healthcare policies that religious institutions provide will not themselves have to cover the objectionable services. But the individuals who are covered can call the insurance company and add an additional rider to that policy. Right? It's only by virtue of being covered by that policy that they have the right to do this. They get to add to that policy these additional services at no cost. Right? Now, I submit to you that that is no difference in substance whatsoever, because the policies still cover everything that the individuals are entitled to. That is nothing. I mean, I would say it's a fig leaf, but I think that this proposal actually gives fig leaves a bad name. It is sometimes said that the way this works is that providing these preventive services will actually save the insurance companies money, and therefore they really don't need to charge for them. I think that that's a rather bizarre economic argument. And the first point is that if that were so, then we wouldn't have to have a contraceptive mandate anyway, because profit-making insurance companies wanting to save money would be handing out contraceptives for free without anybody telling them to, if it were so. But it's also simply not so. Take, for example, other prescription drugs for which, under most healthcare plans, including, for example, mine, which I think is a quite generous one, co-payments are required for all for prescription drugs, and indeed a much higher co-payment for branded drugs if you don't use the generic. For some reason, the administration believes that there should be an exception for contraceptive drugs and no co-payments. And by the way, no co-payments even if you use a branded drug, even though generics are on the market for a cost of, I gather, $9 or $10 a month. This regulation allows users to have a prescription, a branded drug instead at no cost. I can see no justification for that other than possibly a giveaway to drug companies who will be able to profit from that. But take an example that I'm familiar with, which is blood pressure medication. Right, so I take blood pressure medication. If I did not take it, I would greatly increase the chances of having a heart attack, and it would be much more expensive for my health insurance to have to treat that than it would be for me to be taking generic blood pressure medicine. But do they give it to me for free? It would save them money, right? Because preventive care, like my blood pressure medicine, is cheaper than the heart attack that I might very well have if I didn't take it. But no, they do not, in fact, give that to me for free. They give it to me as part of the coverage. It's paid for, and I have a co-payment, which I pay every time that I pick up my prescription. Nothing in life is free. The money is going to come from somewhere, and the only place it's going to come from is the premium that is paid for the coverage. So it seems to me quite clear that even with the so-called compromise, that this proposal places a substantial burden on the religious institutions. So let us then ask, well, what is the governmental interest? It seems to me quite clear that all this is about is cost shifting. That it's, instead of the government itself providing the service that it thinks is important, it's trying to shift the cost onto employers, including religious employers, which is not a compelling governmental interest at all. But how do we, in law, how do we make the judgment as to when interests are compelling? Because it's a very sort of political, subjective question. What we do is we ask, do other institutions in similar circumstances insist upon the same thing? Because if something's truly compelling, then in other analogous circumstances, the government is going to be taking the same view. Well, first of all, many states already have contraceptive mandates, but none of them impose them in the same sweeping, exceptionless way that this proposal does. Most of them allow religious employers to self-insure and thereby not provide the contraceptive coverage. And there are other ways it's dealt with as well. If you look at past proposals, when Hillary Clinton tried to work toward a similar health program back in the Clinton administration, the version of that bill that passed the Senate Finance Committee included a very broad religious accommodation. If it was okay back in 1994 in the Clinton administration, I do not know why it is not a permissible or a reasonable accommodation today. And in fact, if you look at the whole panoply of federal health care laws, to my knowledge, every one of them that potentially might infringe upon religious conscience has an exception. And what's more, even this rule has exceptions that affect millions of people. If it were a compelling governmental interest to make sure that every employee gets this kind of coverage, there would not be, for example, the exceptions for houses of worship. There would not be the exceptions for grandfathered policies. Remember, President Obama promised us that we would all be able to keep our own coverage, right? Well, that means that policies that were in place before have been grandfathered and do not have to be changed to conform to this new law. Literally millions of Americans will still have the same coverage as before with no contraceptive mandate attached. If it is okay to exempt millions of people in order to comply with a political promise made by the president, I suggest to you it is okay, it is not going to be a great problem for public policy to exempt institutions on account of religious conscience, a much more, I think, much weightier consideration. How else could the government achieve this purpose? Because under the Religious Freedom Restoration Act, they have to use the least restrictive means of doing that. Well, they can simply do it by expanding the programs that Helen Alvarez referred to. Title X already provides low-cost contraceptives to millions and millions of people. Let the government expand its programs if that's the purpose, but it should not be allowed to require churches for whom this is a moral evil to do it for them. Thank you.